We are living in a period of intellectual abundance. So much happened in the last 2 decades. We are living in expanding global possibilities. Intellectual property rights is a huge area of opportunity as well as threat for countries. Let us spend 10 minutes on IPR global scenario and opportunities in India. Intellectual property laws in India was in catch-up mode until 2016. When it comes international business and investment in India, there was always this feedback of too many IPR violations and absence of right policies and practices. India is believed to have an incredible potential to become one of the leading markets in the world and a hub for innovation, research and development. The intellectual property industry is also assessed to have a huge growth potential in the current Indian and global context. With slogans like Creative India, Innovative India, India has been trying to position itself to be a pro-IP, knowledge-driven economy. India being signatory to the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, several new legislations were passed for the protection of intellectual property rights to meet the international obligations. These included trademarks, patents, copyright, industrial design, geographical indicators, designs of integrated circuits, plant varieties, information technology, cybercrimes and data protection. Embracing excellence in intellectual property laws in India would require complete understanding of Trademark Act, 1999, the Patents Act, 1970, the Copyright Act, 1957, the Designs Act, 2000, the Geographical Indications Act, 1999, Layout Designs of Integrated Circuits Act, 2000, Plant Varieties Act, 2001 and Information Technology and Cybercrimes Act 2000. India has been a World Trade Organization, WTO, member since 1995. India is also a signatory to international IP agreements like Budapest Treaty. It provides guidelines for the deposition of microorganisms with any international depository authority for the purpose of patent procedures. Berne Convention. Under this, each member state recognizes the copyright of authors from other member states. Paris Convention. Under this, any person from a signatory state can apply for a patent or trademark in any other signatory state. Madrid Protocol. Under this, a person can file a single trademark application that will provide protection in multiple countries. Washington Treaty. It facilitates patent protection for an invention simultaneously in a large number of countries. Marrakesh Treaty to facilitate access to published works by visually impaired persons. Nairobi Treaty for protection of Olympic symbol. State-of-the-art, integrated and IT-enabled intellectual property offices are set up across India. Patent and Trademark Head Office at Calcutta, Copyright Head Office in Mumbai with IPR offices at Delhi, Ahmedabad, and Chennai. Recognition of international standards of copyright protection and incentives for intellectual property have helped India jump 8 places to 36th position on the International Intellectual Property, IP, Index, the highest gain for any country this year. Still, I am not sure whether it is good news. Can you imagine that we were at 44th place out of 50 countries in Global IP Index? As you can see, compared to top 5 countries' average score of 92.2%, we are at 36%. If we are to catch up with top 5 countries' score, we have 56% more to score. This means we have a huge role in moving India's IPR index further up in the global IPR platform. This truly means company secretaries practice expansion opportunities. Every single index point growth means new business or enterprise, leading to new incorporation. Every new trademark and patent registration provides opportunity to enter into international license agreement. IPR Committee recommended investment in IPR talent development in India including schools and colleges. Our millennial talent innovation mindset is a big opportunity. Which means more patent registrations. Company secretaries can coach and mentor young talent and turn them into entrepreneurs. IPR policy shows government's intent and aspiration to stimulate domestic IP creation and innovation in India. Specifically, the IPR think tank has outlined a vision to make India a country where creativity and innovation are encouraged for the benefit of society. Advancement in science and technology, arts and culture, traditional knowledge and biodiversity resources are promoted by IPR, and the IPR think tank has called for establishing an IPR system that would promote innovation and creativity in a knowledge economy, accelerate economic growth, employment and entrepreneurship, enhance socio-cultural development, protect public health, food security, and environment. Implementation of 2016 IPR policy and process simplification lead to dramatic increase in number of trademark and patent applications. IPR think tank constituted include 300 stakeholders, 31 department and representatives from 5 countries. Since 2016 policy formulation, separate gateway for e-filing of trademark applications, 50% fees concession to micro, small and medium enterprises, trademark hash journal, published every week, real-time online status available in IPR portal, international trademark can be applied with one single application as per Madrid Protocol, 80% fee concession for startups and expedited examination of patent application. I see great opportunity for practicing company secretaries to leverage professional network and educate clients in IPR areas and offer list of IPR services. These are just indicative services I could think of, not exhaustive service catalog. Moving on to other IPR areas, 2 important non-organic developments or growth we can identify are cybercrimes and data protection. In the next few minutes I will do a quick update on where are we on these 2 areas. When I was practicing law, I used to appreciate Lord Macaulay's futuristic vision and think he has come out with Indian Penal Code exhaustively covering all possible crimes. But outburst of World Wide Web, cloud computing, mobile technology and many other IT developments, IPC, CRPC, Indian Evidence Act and all other legislations are not sufficient to bring order in the society. There is a huge gap of cyber law professionals globally. Many of these crimes are turning out to be international crimes that requires techno-legal understanding and many other skills. Good news is, this opens up many more professional opportunities to practicing company secretaries. You may want to consider some or all of these services. Cyber law advisory and consulting opportunities are exploited big time by Big Fours globally. Billing turns out to be in millions of dollars. I will share some high-level updates in the data protection practice areas. Draft GDPR bill in India borrow from European Union's General Data Protection Regulations. Some important provisions in GDPR are penalty of up to 4% of annual revenues for data protection violations. Restricting data use when it is not necessary. Appointment of data protection officers by companies. Inclusion of data protection while designing technology. Users' right to port their data to another company in the event of mergers and acquisitions, etc. Once data protection bills is passed by both houses, it will enhance the opportunities for company secretaries further. A central data protection authority will be set up. Provides for stiff penalties in case of violations, increasing opportunities for data audit, IT audit, compliance audit, etc. Companies will have to appoint data protection officers. Company secretaries in current statutory role may double hat as data protection officer. Thanks for your time. Please feel free to connect with us for any further clarifications. You may watch other IPR videos in our YouTube channel to get more clarity on IPR and cyber laws.